The broadcast is now starting. All attendees are in listen-only mode.
Hello, and welcome to the newest edition of Nelson Mullins' 2021 Education Law webinar series. We're glad you could join us today. My name is Dan Cohen, and I'm a partner on Nelson Mullins' Education Law team. Nelson Mullins is an AmLaw 100 law firm with about 800 attorneys and policy advisors across 25 offices in 11 states plus Washington, D.C. Among other practices, we have a dedicated team of attorneys focused on serving all legal needs of education institutions, including in the areas of labor and employment, healthcare, and issues affecting academic medical programs, construction and real estate, intellectual property, privacy and information security, and unique issues facing education institutions like student and faculty discipline, sexual misconduct, and athletics. As we did last year, we host free monthly webinars addressing legal topics across these areas, and sometimes more frequently as issues arise. So please feel free to contact one of our education lawyers if you have any questions about our webinars or any other legal issue affecting education institutions. And if you have ideas for future webinar topics, please let us know via the question box or the feedback form during or after today's webinar. Today, Cheryl Shaw, Suzann Wilcox, and Laura Lashley are going to focus on negotiating software and IT contracts for educational use. They'll talk about click-wrap agreements, indemnity provisions, limitation of liability provisions, data ownership and use rights, and we'll also talk about privacy and security requirements as well as other topics. Cheryl Shaw is a transactional partner at Nelson Mullins with an LLM in taxation. She practices in both the public and private sectors. Cheryl provides education clients with advice in a broad range of transactions, including contracts, real estate, construction, finance, SPLOST, procurement, tax, and E-rate matters. Suzann Wilcox has been providing legal services to a variety of education entities for the past 2 decades. Suzann focuses on policy and process development, legal training for staff at all levels, board and superintendent advisement, day-to-day issues impacting schools and students, and technology and privacy concerns. As one of the partners on our team, Suzann works to get clients to a place of yes in a legally compliant fashion. Laura Lashley is taught at the K-12, undergraduate, master's, and doctoral levels, and uses her experience in the classroom to provide practical advice for clients across public and private educational sectors. She focuses her practice on federal and state education policy, flexibility reform, charter schools and systems, data privacy and security, and employment matters. With that, I would like to turn it over to our speakers.
Well, good afternoon. I hope you're all doing well today. I'm Suzann Wilcox. As you can tell from our pictures and then our webinar presence here, we've all had a bit of a hair evolution since those pictures were taken. Except for me, I kind of have a go-to style, but Cheryl and Laura, who's actually joining us from Philadelphia, we are in Atlanta, Georgia. So just so in case you were confused thinking, who are those ladies in the pictures? Here we are. I just want to go over really quickly kind of what we're trying to accomplish with you today. Thank you so much for joining us. I know especially these days you're very busy. You have a lot of demands on your time, and we appreciate you taking some of that time with us. We all know that the digital transformation of education is in full throttle, and it's been in full throttle. Apps, technology solutions, they're being routinely used for instruction and educational operations. Virtual learning is now by way of blended or hybrid online instruction, and it's just become a way of life, especially since the pandemic. And frankly, we don't see that changing anytime soon. Today's webinar is going to help you negotiate contracts to license software, buy software as a service, and other cloud computing offerings in this digital age. We'll discuss things to consider, common pitfalls, and provisions to negotiate. And if you see the slide that we've got displayed here, these are some of the things that we have as goals for today. We'll be discussing how to ensure functionality for your intended purposes, how to adequately protect privacy and data, how to negotiate for prompt remediation in case of a technical or data issues, including maybe a breach, how to avoid common pitfalls of technology contracting, and then your indemnification and practical legal remedies. Of course, we are going to be giving you sort of a broad overview of what the laws state. If you are not in Georgia, but you are somewhere else across the country, a lot of the information we're going to share with you today is federal, but some of it will be state related. And we're just going to give you Georgia as an example. But certainly when we discuss state, you'll need to make sure that you are looking at your state's particular rules and regulations. And we'll highlight that for you as we continue our discussion.
Okay. So our first topic for today is ensuring functionality for your intended purposes. And this is a pre-contract piece and actually pertains to what are you actually buying. Vendors generally refuse to warrant that the software or the solution is fit for any particular purpose, right? So it's important for you to read the specifications and ensure you're getting the functionality that you need. Now, some vendors will offer standard specifications and they're not negotiable, but you can always try. And when you start negotiating or looking at the functionality that you need, I always find that it helps if the client describes the functionality that they need in everyday English, okay? For example, and this is especially true for mission critical solutions that you're purchasing. Include your intended purpose and describe that functionality in terms that a layperson could understand. For example, we are purchasing an accounting-based service as a solution software that provides the following specific functions, these specific reports that interacts with these specific funds and that kind of thing. It is important, obviously, to test and have demonstrations and to pilot the product before purchasing. With that, it's important to ensure sometimes these vendors will come in and they will give you a demonstration that doesn't really show the core functions that you need. So make sure that their product already shows the core provisions that they can give to you, and ask, is customization needed? If customization is needed, then how much is it going to cost to make sure that the product does the functions that you want them to do? One of the important things, again, is that the contract, these vendors won't typically warrant the functionality or the specifications. So we find that it is helpful if you attach the final agreed specifications or function descriptions as an exhibit to the contract, rather than relying on the typical warranty, which states that, oh, this software will perform in accordance with the documentation. Well, what documentation? If it's not attached as an exhibit, if it's not expressly defined, then you really don't know what you're buying. And remember, the contract always trumps the sales pitch. So we've had a lot of clients come to us and say, hey, but they gave us this and they showed us this, and here are the promotional materials, but you're looking at the four corners of the contract. What is contained in the contract will bind you, not the sales pitch.
And that happens a lot. We see that happen a lot from time to time, where they will say, they'll get this beautiful glossy presentation and it looks so good. And then later the product is junk, frankly. It just doesn't do what they wanted it to, or maybe it just doesn't do what it's been purchased to do.
Or it will do what you want it to do if you pay them additional money.
For an extra 400%, we'll be happy to do exactly what you asked us to do the first time. What I always tell our clients is, look, when you and I win the lottery and we're gone off somewhere, this contract should say exactly what it would need to say for the person coming behind you to understand what this thing is supposed to do. So it's when you win the lottery standard. That's the one you want to use for your contract.
Okay, I'm Laura Lashley, and I just want to say, I know that we have a variety of folks on this presentation. You may be a lawyer familiar with all the jargon we're going to be spouting, or you may be a layperson at your organization, like a tech director or a procurement official or someone like that, who's routinely reviewing contracts but maybe doesn't have the legal support to have a lawyer negotiate all your contracts for you. Or maybe you're a principal, at a charter school or, otherwise, that's having to do this all by themselves. And so we're going to try and break down some of this stuff for you, be applicable, understandable at least for whatever situation you're in. But do understand that tech contracts are hard. They're one of the most difficult contracts we negotiate. And part of that's because there's very few people who are both an attorney who's, skilled at negotiation and also somebody who understands all the technical jargon. So don't be afraid to lean on your technical folks if you are that principal or a procurement official. They need to be side by side with you looking at all of this because they can tell you how strong the protections are, or how weak is most often, or what they're trying to get away with. So the very first thing you got to look at, okay, you figured out what you want to buy. You've got your functionality squared away. You've written out exactly what you want, and you feel like you have a vendor who's going to provide it. Now it's time to enter the contract. Well, the reason why tech contracts tend to be more difficult is because they have so many parts to them. And tech vendors are notorious for this, but even a simple quote will have like a tiny little boilerplate at the bottom. This is governed by the terms and conditions, master services agreement, service level agreement, and if you're in Puerto Rico, this agreement, and if you're in Canada, this agreement, and it's just this long list of links that are at the bottom of your quote, and you don't know what you're agreeing to. And the temptation there is just to hope for the best. I think that's what most people do when they're entering into tech contracts. It's like, let's just, I'm not going to sue them if they don't sue me. Let's hope it works. Sign the dotted line. But that is not what you should do. And I'm not just saying that as an attorney who negotiates these routinely for my clients. And the reason is because there's some stuff in there. There's some sneaky stuff in there, and you got to look. So the very first thing I always recommend my clients to do is not to use the vendor's contract. You don't have to use their contract. You can make up your own beautiful digital template that that has all of your organization's must-have terms, everything, all of your priorities are outlined in this template. And then you can have in the body of the agreement, vendor, any of your terms and conditions, terms of use, and user agreements, whatever they want to try to bind you to, they can attach that to your template. And just make sure your terms always trump theirs. And that's what we do with every client that I represent. We have a template, and so if you don't have something like that, encourage your legal department, if you're lucky to have one, to make one of those for you, or hire a wonderful education law firm to help you out. But regardless, start with your own template if you can. That way, that if your terms trump theirs, they aren't going to be able to sneak anything in there, on page 42 of their master services agreement that you fundamentally cannot agree to. Because a lot of these things that they put in there are actually illegal for public institutions to agree to, or against your best interests at the very least. So if you are using a vendor agreement though, because you have not had time to make a wonderful digital template, the first thing you need to look at is what are they trying to get in by reference? What are the links? Because if you don't have all of those things printed out, keep the slide where it is, please.
Okay, sorry about that.
If you don't have all of those documents printed out and reviewed, you don't know what you're agreeing to. So what I like to do is I print out every single thing that they have, that they're trying to include, and I go through and I negotiate. I say, no, we're not going to agree to that. I cross things out. And then when we have a final negotiated agreement, because a lot of people don't realize you can negotiate the terms of use. Now, if you're the average Joe person consumer, you can't negotiate the terms of use. You just got to let Big Apple do what they're going to do to you. But if you are working for an educational institution, you've got leverage. You can negotiate even their terms of use, their privacy policy, all of those documents they try to put in there. So mark it up, send it back to them, and then you print it out and you attach it to the quote or whatever the contract is, and it's memorialized, and you don't let them unilaterally modify what you've printed out and negotiated. And that's going to be your best bet if you have to use the vendor contract. In a procurement situation for my public institutions, the big thing here is making sure that your solicitation actually contemplates a digital purchase. A lot of institutions have solicitation templates that were developed very broadly for goods and services that just do not contemplate tech software, digital agreements, and the kinds of things that you need in there. I've been going through with my clients and helping develop exhibits to attach if it's a digital purchase that contain all of those software specific terms and conditions you need in your solicitation. So that's one thing you need to do there. And then always make sure your organization's terms are going to take precedence over whatever they include. And they always do this in solicitation responses: no links allowed. Every single thing they want to hold you to needs to be printed out and attached to their response to your solicitation.
Because one of the dangers, and we'll talk more about this, is that when you have a link, they can go and change what's at that link. So as Laura said, sneaky behavior. And we want to try to circumvent that at every turn.
Okay, so pitfall number 1. This one is near and dear to my heart because a lot of times I get word after we're already into an agreement that a teacher or a professor or somebody at the classroom level has agreed to use the software, you know, and clicked on the agreement. So just that I accept without even reviewing it. Or, you know, if they were feeling, you know, motivated that day, maybe they skimmed it, you know. But the fact of the matter is, those end user, we call them EULAs, end user license agreements, are typically what you're clicking accept on. Those contain all sorts of terms that you do not want to agree to. And if you're a public institution, you legally can't agree to most of them. So, you know, we looked at different types of EULAs out there just to give you an idea of some of the crazy things companies include. There's such, Amazon put a zombies clause in their EULA. There's firstborn children, immortal souls. One company, I thought this was wild, said that if you read this far, contact this email address for a prize. And they gave the person who finally did it 4 months later, 3,000 downloads later, $1,000 just because nobody ever reads their actual agreement. So it's in your best interest to read through that. But in all joking aside, there are serious terms in there that are very bad against your interests. They're great for the vendor. Things like mandatory arbitration. Well, arbitration is really expensive, and especially for my public institutions, we typically don't like to go to arbitration. You know, the average citizen can't afford arbitration. If you're a charter school, you definitely don't have the budget for arbitration. You don't want to be roped into a specific legal remedy that you haven't signed off on, because chances are, if they like it, it's not going to be good for you. Another thing that they will put in there in those EULAs is that you're taking responsibility for anyone who may be using the software and all their actions. Well, any teacher will tell you they do not want to be held legally responsible for what a child does on a software that they've downloaded for their classroom, and yet they've signed on to taking full legal responsibility for that. And one of the worst terms in there is indemnification. Almost every, I mean, I would think pretty much 99% of EULAs out there will have an indemnification clause stating that whoever downloaded the software will personally indemnify the company of any wrongdoing done by anybody who is using that software. And, you know, an average consumer cannot afford that. And you don't want a teacher or a professor agreeing to that, something that you legally cannot agree to, because, you know, public institutions in Georgia cannot agree to an indemnification clause of an external party. So, you know, as I said before, you don't have any leverage as an individual consumer with those click wrap agreements. So, you know, if you want the software, you want the iPhone, you're going to have to click agree or, you know, buy something else. That's your leverage, just buying something else. But when you're an educational organization or an institution like a public or a private university or a charter school district, you have leveraging power. You have buying power. And you can negotiate a lot of those terms. So next slide, please. You went too far, I believe.
Sorry about that. Let's see. There we go.
Got an eager trigger finger. Okay.
I am fast on the finger today.
Okay. So this is where I harp on people downloading free apps. I feel like I hear this all the time, you know, well, it was a free app. How bad could it really be? I mean, it's free, you know, to use in the classroom. Well, the fact is nothing is really free. And I think free apps tend to be the worst. And the reason why is because they're going to make money somehow. And if they're not charging you money up front for the software or the app or whatever they're giving you, it's because they're selling your data or advertising to you. And both of those are legally loaded when it comes to students. You don't want to agree to a company selling your students' data. You do not want to agree to them advertising to your students or making advertising profiles based on your students' data. And that's how they make money. And so that's like the number one thing that teachers are going to be downloading for their private use, or not private use, but for their use in their classrooms. So what we like to do for my clients is have, some kind of technology committee that reviews every request to use an app or a software or a device that comes up from the school level, and we do a review for safety. We look at the terms, we negotiate the contract if need be, and then once we've approved an app, then any school or classroom that wants to opt into using it can, and we know that it's safe, and we know that we have a legal agreement on the books. That probably sounds like a lot of bureaucracy to some, but the fact of the matter is you do not want a wild, wild west situation with teachers downloading this, that, and the other and exposing your students' data to it without you knowing. So that's our best recommendation for that situation, is just limit who can download software, who can download apps, and then expose your students to them, because it's a legally loaded situation.
And Laura, this is Cheryl. So normally, you can also set up a system where if you have, so that you can vet the app. So if an app is approved for, let's say, one professor or one teacher, then you can set up a website or a central place where others can see that that app was approved, so that you don't have to go through all the vetting each time that contract may want to be used by another professor or a teacher, within the educational institution. So that's a way to create efficiency as well.
A lot of our clients actually put together what they've called like a marketplace or a clearinghouse where staff can go in and check and see, is this something that's already been approved? It also, for you instructional minded people who are thinking, but also, is it a good app? Is it helpful for our teachers? Are we going to be spending time, valuable instructional time on this app that isn't useful? That gives you a chance to vet it for instructional appropriateness, age appropriateness, and other issues. And as Laura said, if you are not, if they're not charging you, you are the product. So don't forget, that nothing is free in this world. It's just not. So they are definitely taking something from you to make money.
And, some of you may be sitting there thinking, I can't control what my teachers do in their classroom, or, if I'm a school district head, there's hundreds and hundreds of employees that I would have to watch out for. And the only answer I have for you on that is that you need to factor this tech acquisition situation into your policies and procedures, and you need to train your employees on it. It needs to be common knowledge that they cannot download an app and use it in their classroom without it going through your organization's process that you've developed.
Okay, so moving on, we're going to talk now about pitfall number 2, which is that vendors will often incorporate agreements into your primary contract by reference. And these incorporated agreements will sometimes modify material terms. And we're going to show you a few examples by that. So particularly when you're using software as a service, software as a service is a hybrid of a service agreement and a license agreement for the remote operation of software. And that's, while we find vendors incorporate external agreements into the contract, generally, and you just expect it to happen. It happens more often with the software as a service applications. So here are some examples, So you've negotiated your who, what, when, where, and how, And you say, okay, this is what I'm getting, this is what I'm agreeing to. But way down in the boilerplate provisions of the contract that you signed, there are these sneaky little provisions, which says, well, or in the definitions. The definitions is a great place where they bury hard to understand or terms which may change what you think you're agreeing to. So here are a few real live examples from contracts. Service level agreements mean the then current service level agreement available at this link, right? Privacy addendum means the then current version of the service offering at this link. Service description, the then current service offering service at description document available at this link. Well, what does that mean? Then current doesn't mean what you've agreed to today. Then current is what they have attached at the current time that's posted at their website, and you have no notice of that. So you have no notice of whether these agreements have changed, modified, or impacted your terms. And that's why, like Laura said, it's so important to print out exactly what existed when you signed the agreement, attach it, and get rid of all of these links within your agreement. Because obviously we're trying to make sure that the incorporated agreements don't conflict with the terms that you've agreed to. That they don't include terms that are unfavorable to your organization or that you can't legally agree to. And it's important to remember, before the contract is signed, that's when you have the most leverage. That's when you have your bargaining power, particularly over these high dollar technology solutions. All of these are negotiated or can be negotiated for the most part, unless you're dealing with the huge technology giants. It's a little more difficult. But you do have the power, and they're just hoping that you're going to ignore or gloss over those definitions and those links that are incorporated by reference.
And 2 points there. I mean, what you'll find is that your salesperson, who's a lovely, gregarious person that you would invite to your, holiday office party, is not going to know what this contract says. The CEO that you're friends with, that you've met at several events, they aren't going to know what the contract says. I promise you, Cheryl and I have sat in meetings where CEOs have been super nice and lovely, and when we tell them what their contract says, they've sort of gotten angry at their attorneys for putting that stuff in because they didn't even know it was there. And then also, one thing we found, just a little practitioner point here, even when you're dealing with some of the giants that you feel like we're never going to be able to negotiate with X, Y, or Z, Google, Apple, whoever, we have found that if you have friends in the industry, let's say you have a friend who works at a very large school system out west or up north, or even a large Department of Education, you may want to reach out and see, has anyone negotiated a contract with them that they thought was helpful? Because what we found is helpful is to say, you're saying you can't do this, but we see that you negotiated this contract with so-and-so, so maybe you could give us the same deal. That's very hard for them to say no to because they've already agreed to it once. So if you have some connections in a larger, more advantageous buying position, you might be able to piggyback and take their terms and make them yours and kind of put that company in a corner a little bit.
Yeah. So some of these boilerplate provisions, which again, I mean, when you negotiate your contract, you're primarily focused on the who, what, when, where, and how. I, university, I, school district, am buying this technology solution from this vendor. I'm going to pay X for it. You're going to implement it on X date. It's going to go live on X date. The who, what, when, where, and how, right? Way down at the bottom of your contract, you will find what we call the boilerplate provisions. And in these boilerplate provisions are sneaky, sneaky little provisions which can greatly impact and negatively impact your agreement. Some go so far as to allow the vendor to unilaterally change the agreement. Again, we have some samples here of real-life contracts. You'll see 12.1. We may periodically change the service offering. It is your responsibility to check the portals for update. 15.2, this agreement, as it may be revised by us, is the entire agreement of the parties regarding its subject matter. So if you sign this without striking, the as may be revised by us, which is probably, on page 20 or further in the contract, then you've agreed that the vendor can unilaterally revise the terms from what you have agreed to in your contract. And clearly this puts you at risk for unfavorable service changes. And in addition, it could actually subject your organization to FERPA issues. FERPA applies whether the student is actually in the classroom physically or being taught through a distant learning platform. And under FERPA, the vendor in order to be, for the vendor to be designated as a school official, the vendor must be under the control of the educational institution, right? So if you have a contract under which the vendor can unilaterally change the contract, then there is an argument that perhaps the vendor is not under the educational institution's control. So,
and we'll be talking a lot more about FERPA later in the presentation. And for some of you, FERPA doesn't apply, but it's still a good practice to, even if you're a private institution, to kind of know what FERPA requires. And I have a lot of private institution folks that try to model their processes off of FERPA because it does provide privacy. So we'll talk more about that.
Another big pitfall is pitfall number 4, in which the vendor disclaims any and all warranties, with respect to the product. And you can see here is another example where the vendor makes no warranties whatsoever as to any matter, including performance, results, security, non-infringement, merchantability, integration, quality, enjoyment, et cetera, et cetera, et cetera. So infringement, here, the vendor is not even warranting that what the vendor is selling or licensing to you, that it doesn't infringe. They're not even warranting they have the right to sell it. They're not warranting that it will work for the application that you want to use it for. The typical contract warranties that we like to see in a technology contract will include things like performance and functionality. With respect to performance and functionality, the vendor is going to give you, try to give you at best, the software will perform in all material respects in accordance with its documentation, which really means nothing, right? I mean, I don't know where's the documentation? What does it say? And that's why, again, we recommend that you attach the specs or the functionality, a good description of that to your actual contract. We absolutely require that the vendor provide a no infringement warranty. If the vendor's product infringes on someone else's product, you want the vendor to pay, your institution to pay the lawyers, to pay any settlement fees because of the infringement suit, plus any and all other normal contract remedies that you have. And that also ties into, the right to license or sell. We want to make sure that they are a licensed distributor or have the right to license and sell that product. The warranty that the software will not contain any viruses, which will take your system down. That's important. And obviously, the vendors absolutely must provide a strict data and privacy protection warranty. You don't want to end up in a situation where you signed a contract and you thought you were getting this beautiful, beautiful product, and then you end up getting something like this.
Which looks like my first car in high school.
Yes, I think it was my first car. Laura?
Okay, well, so let's say this is another thing that's in every tech contract that I see, and it's if you're working with the vendor agreement, they're going to try and write it in such a way that it benefits them. That's just how it goes, right? And one of the ways they do this is by trying to state what law will govern the contract, and they always want it to be their home state. And that's understandable too, but the fact is, especially if you're a public institution, you cannot agree to that. You are a creature of your state's laws. You are held to them. You have built-in protections under your state laws that you wouldn't want to get rid of. And not only that, I mean, it's about your home court advantage. If you're held to a different state's laws, you're not going to be as familiar with that state. Your attorneys won't be as familiar, most likely, and you won't know what pitfalls you could be getting into if you agree to another state's laws. The only time that I will agree to this, because I strike it every time, I change it to Georgia law for my clients every single time, with the exception of when we are entering tech contracts with another educational institution. Sometimes public universities in other states will develop software and apps that they license to school districts or other universities for very, very reasonable prices. And it's kind of like a very collegial agreement already. Those agreements tend not to be bad at all. They tend to be very fair when you're dealing with another educational institution. And they might be held to the exact same legal requirements that my client is, in terms of what governing law they can agree to. And so in a situation like that, where the risk would be very low of litigation, what I've done in the past is carve out the provisions that really matter to me and make those subject to Georgia law or whatever state law my clients are. Under Georgia law, according to Georgia law, this indemnification, blah, 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 that sort of thing. But generally speaking, don't agree to any choice of law outside of your home state. Again, you might not win this if you're negotiating with Google or Apple or something like that. But most tech vendors will agree to that, to change it. Let's see. Can you next, please? The other thing that you don't want to agree to is a different venue than your state. And the reason why is, okay, wait, we're going, okay.
Sorry about that.
The reason why is you don't want to have to fly somewhere to defend yourself if you get sued. You don't want to have to, it's the kind of thing where, if they did something terrible to your organization, but let's say you're a charter school or a small private school, small private college or institution that doesn't have a huge legal budget, you might just end up taking it on the chin because you can't afford to litigate it, in Hawaii, as nice as that might be. So make sure that you change the venue and the choice of law to your home state.
And, sometimes we will, if we're desperate and we don't really have any other options, sometimes we'll just take it out and not have it be silent on it. And at least at that point, you've got an argument that it's your venue or your choice of law. So if you're backed up against the wall and they won't agree to change it to your home state, you can always say, well, let's just be silent on that. And then at least it gives you a shot at arguing otherwise, if it all goes to where. So.
Yeah, as the very wise Cheryl Shaw once told me, just get it to where you can fight. If you can't agree to the best, just get it to where you can fight.
Exactly.
And that's very true. Okay, so a next pitfall is when the vendor in their agreement purposefully limit the remedies that would be available to you if they screw up. You don't want to let them get away with it. Vendors will figure out all kinds of sneaky ways to carve out of to get away from their accountability under the contract. They do this in a couple of big ways. Primarily through a limitation of liability clause. Those are one of those that are like the warranty. They'll do it in all caps. They're like, just so you know, we are not liable for anything if we screw up anything. They don't sneak that one by. That's usually right there in your face.
Loud and proud.
Yeah, and the way that those limitations of liability works is they say, okay, assuming that they'll agree to be liable for anything, they cap it at usually 12 months of the contract price. If you're working with, a big tech vendor or like a tech supplier, like you're purchasing 1,000 laptops or something, 12 months of a contract price is a pretty big remedy, so that might not be so terrible to you. But a lot of times these tech contracts might have a value of like $3,000 or $4,000, but it's a very sensitive thing that they're dealing with. Like maybe their software touches on your student information system, something that if they have a virus and it goes wrong, the damage to your system is going to cost a lot more than that 12 months contract price. So you can negotiate that. You can 12 months is what they try to get away with. They will tell you it's industry standard. No, it's industry standard to insist on it, but that doesn't mean that you can't negotiate it up. We sometimes go up to 24 months, 3 years. We mess around with the multiplier to get it to where we think, okay, we know that with this amount of money coming to us, we'd be safe. And another way to deal with those is to carve out certain types of vendor behavior that would be more expensive and problematic if they mess up. Things like willful conduct, gross negligence. You can say, okay, you can limit your liability to 24 months of the contract price, except for instances of vendor misconduct, gross negligence. You can make those carve outs, and that's a real practical way to deal with those limitations of liability.
And
Another
Laura,
way Oh, sorry, go ahead.
I was going to say, and I would add, another carve out, a good carve out would be for, data and privacy breaches, right? Because with that, we don't care if the vendor, for example, even did anything wrong. They could have the strongest security measures in place, right? But we want that vendor to be liable for the outcome of any data breach. So if the student's information is, sold and published all over the dark web or whatever, then you want them to compensate you for that outcome. And you want them in that instance to pay for the cost to recover and the third party claims that may arise from that. So that's another one that I think that's always should be carved out if you can.
Absolutely. Another way that some vendors, and this is going to be your smaller tech vendors, the single apps or things like low cost contracts, another way they try to get around being held accountable is by carrying really crappy insurance. You need to have in your mind, okay, what limits of insurance do we require? Is it 1 million for general liability? Is it 3 million for cybersecurity? What do we insist on as a policy for our institution? And then you need to put that into every vendor contract, scratch out what they put, say what you require. Because if they don't have the money to compensate you for the harm they do because their insurance is crap, then you're still left without a meaningful remedy for their poor behavior. Another thing we often put in is having a best rating of A, because some of these insurance policies are super cheap, and it's because they carve out a million things that they won't be responsible for, if the vendor does. So you want to make sure they have sufficient insurance.
And can I add to that, Laura? I mean, you also want to make sure that, sometimes when you limit your liability cap, right, that your limitation of liability provisions and carve out align with your insurance coverages. So if you have, for example, $3 million worth of coverage for cybersecurity, right? You don't want to limit the liability there or their indemnification to a lesser amount. So, to the extent that the insurance is available, it's a good idea to have the insurance, if you can, trump the liability cap.
Yeah, that does get into nasty fights a lot of times with vendors.
Yeah,
so if you have legal counsel, they will fight you on that one. But that is best case scenario. If you can get it by, The third big way that they get out of accountability for what they do is through an indemnification clause. And for my lay folks, indemnification is when you're saying, okay, if you guys get sued by somebody else for something we do, we're going to cover all the costs associated with it. So in theory, that's a great promise for a vendor to make you. But it turns out to be meaningless if they say, we'll pay for any third-party claim except for ones, stemming from, a 5-line block of exceptions in parentheses, which is often what happens. So you really want to look and see what are they saying they don't have to do. Cheryl, when we were discussing this, pointed out a really good one that I have seen before. Sometimes one of the ones that they'll say is, okay, we'll indemnify you, except if you go and use some third-party software, third-party technical device, and it makes our product not work right, that's on you. Well, every product that you're going to use the software on is going to be a third-party device, right? I mean, unless you're using Dell software with a Dell laptop, So the point is that's a pretty big out that they've created for themselves. So you really have to watch what they're trying to carve out of the indemnification, because it'll be meaningless if they get out of enough of it. And they often, what I see in vendor contracts more often than not, is that they want to. The only thing they want to indemnify you is infringement. That's the only thing most of them will put up front. So it's really up to you to argue all the other things like gross negligence, the willful misconduct. I mean, we put out of any action that you do that causes it. I mean, our indemnification standards are really broad.
Well, and also, Laura, I think it's important to figure out what is the probable risk you know, what is the probable risk and what's the cost of that risk when you're dealing with that software, and negotiate and customize your negotiations based on, you know, based on that. For example, too, like a practical remedy is, you know, controlling the payment of funds. So if you're worried, for example, you know, oftentimes these vendors will require you to pay for, you know, the software as a service or anything up front, or the software up front before it's even really implemented or approved or accepted. So, you know, negotiate the timing of your payments as well, so that you can make sure that it works, that before you pay in full or pay that substantial payment. For your downtimes, if a system goes down, you can use system credits, you know, credits back to the ongoing maintenance or licensing fees to compensate you for the time that the system was down. So, you know, try to use practical remedies. First, look at what the risk is, and then figure out what is a good practical solution for compensating you if that risk occurs.
Yeah, absolutely. And, you know, I was thinking while you were talking that it's a good moment to point out for my lay folks on the webinar who may be negotiating these contracts on behalf of your institution, but you don't have a law degree, or you can't afford having a lawyer on staff to do these things for you all the time. The practical note here is, if it's a big dollar contract, or if it's a very sensitive type of software, it may be worth splurging to have legal review of that one thing if you have outside counsel and you have to pay for it. Because the fact of the matter is, all those practical remedies that Cheryl just listed, you know, timing of payment, refunds, timing, getting system downtime credits and things like that, they are almost never included in the vendor contract up front. So you're looking at a contract that's saying we're not responsible for almost anything, and then it would be up to you to write all that in, and that's complicated for someone who isn't used to all the legal jargon. And so that might be a sign that you need to get some help from an attorney who handles data privacy issues, if you're one of my lay folks. Also, try to do acceptance testing where you can. I feel like a lot of clients just go off a presentation maybe before they purchase. Yeah. But if you can actually have like a trial time with the software, or especially if it's a big price tag, purchase, then you try to get acceptance testing written into your contract so that payment will be contingent upon successful acceptance testing, or something like that.
Yeah.
Okay, next, please. Okay. Okay, so this one is going to be mostly for my public institutions, both public universities and public schools, public charter schools in Georgia. These are Georgia-specific issues. So if you're not in Georgia, these things probably won't apply to you in the same way they apply to my Georgia folks. But you should be aware of your state's laws that can impact. But tech vendors, they're private creatures for the large part. And so they don't know the intricacies of Georgia law when they come in here. And so a lot of times their standard agreements will violate things that Georgia institutions cannot legally agree to. The one I see all the time is indemnification. They try to say that the school district, or the public entity will indemnify them for anything we do wrong. Well, our Attorney General, bless him, wrote an opinion a long time ago saying that Georgia public institutions cannot indemnify a third party because it's a use of our state's public funds that we don't agree with. So we always scratch that out. You can't agree to that. Another one that comes up a lot is confidentiality provisions that would conflict with your obligations to produce records under the Open Records Act. A lot of times they say things like, you won't do it unless you, or every document we give you that is confidential unless we stamp it otherwise, or some crazy thing trying to say that every single thing they give you is trade secret protected. Well, under Georgia law, if they want something to be protected as a trade secret, they have to file an affidavit up front saying it's a trade secret and give that to you at the time they submit the record to you. So there's just not a lot of trade secret protection out there for vendors. And software tech vendors, they're the ones who want it the most because they don't want their IP, their intellectual property to be stolen. So, you have to look out for confidentiality provisions that promise them more than you legally can agree to. Because once they give something to you, it's an open record if you're a public institution, and somebody can ask for it and you have to give it to them. So I always make them aware of the Open Records Act. I write it in. And also I tell them we're not going to give you advance notice because we've got 3 days to comply with the Open Records Act. So you don't want to have to give somebody advance notice because they're just going to drag their feet until you know, and you know what your legal obligations are. You can't listen to them.
And most states have a law like that.
Yeah.
So even if you're not in Georgia, that's something to keep in mind, is to be aware of agreeing to any confidentiality provisions. And also, I agree with Laura. I wouldn't agree to any advance notice requirements either, because if you're a large system, or even if you're not going to remember that that's buried in the contract somewhere. So just, we would take it out.
Another one that they put in a lot is they want to give you a 3-year license agreement. You know, they try to do it a 3-year term with, and that's not always a bad thing, you know, because sometimes you get really good discounts if you buy more than 1 year at once with software licenses. But the problem is in Georgia, you know, we have a provision in the OCGA about multi-year terms for buying things and leasing things. And we have to have a right of annual termination in order to enter a multi-year contract. So that's something that your vendor is not going to know about. So it's up to you to know that that exists and say, hey, we actually can't agree to this unless we have an audit, you know, an annual termination right that helps us get out of it. Because they aren't going to want to let you out of it easy, the contract. So you're going to have to insist on that. Another thing, penalty payments, liquidated damages, arguably late fees. These are all things I argue are against the Georgia Constitution's prohibition against gratuities, which is the reason why we can't indemnify anybody either. I don't agree to any of it, you know, and that's the whole thing, you know. When you're reading these things, you can just get happy with your pen, you know, scratch things out. You don't have to agree to anything up front. You do have leveraging power, especially if you're a big institution. So don't be afraid to say no, especially to, I mean, no penalty, no liquidated damages. That's not appropriate for an educational institution. Okay, next slide, please. All right, now we're getting into the meat of it, which is funny because we have 9 minutes left. So what you really got to make sure of is that the contract, the vendor that you're going to use has strong privacy and data protection provisions. Also practices, but then those practices are embodied in your contract. You don't want to just have them say, the sales rep, oh yeah, we follow FERPA, we do it all, we're great, we're super locked down, can't get in there, and then not have any of those promises put in your contract. Because the fact of the matter is, educational institutions are easy targets. They typically are underfunded, understaffed. They deal with lots of personal sensitive data. And there's a lot of moving parts in an institution like that. You know, you got a lot of different people handling the same stuff, whereas, you know, private corporations usually have the money to really lock things up tight. So you don't want to expose your institution to liability by you know, just not asking the right questions. So the best way to protect yourself, next slide, please, is to ask questions and push back. And this is something that took me a while to understand as a young attorney, when I was young, was don't assume that the vendor knows their legal obligations. You know, a lot of times, especially legal obligations that are state, from your state, they definitely don't know those, but also federal ones. A lot of these vendors are trying to break into the educational market. They're not used to working with public institutions or private institutions that have policies and sensitive data. So it's really up to you to safeguard your students' rights and your employees' information, because some of these vendors, you know, I had a vendor who didn't even know what FERPA was, wasn't aware of COPPA, all the laws that Suzanne's going to tell you about in a minute. So it's really up to you to safeguard your own stuff, to read these contracts and point things out. But the good news is that the big guys like Apple, Google, Microsoft, they are going to know federal law at least. They may not know Georgia law right off the bat, but they're going to know what their federal obligations are. And so they're not going to be as likely to sneak anything super illegal by. Okay, next slide, please. All right, these are some more questions that you should ask. Are the security practices audited by a third party? That is industry standard. So if you've got a vendor who's not doing that, they're cutting corners, you can't rely on them. It's your right to request to review the reports of those audits too. We typically write in a provision saying that we get to see your SOC 2 report, which is a security audit that most vendors use. You need to look at, what happens if there is a data breach? Who's going to be responsible? How quickly will you notify us of the breach? Will you notify us of it if you suspect it or if it really happens? Because a lot of them don't want to tell you about it if they're not sure. And then valuable time goes by. Look at what they're going to do to your data at the end of the contract term. How are you going to get your data back if it's like an information system you're using to house your data? Will it be usable? These are all things that you need to think about. Anytime you negotiate a contract, the most important question is, what's it going to be like if you and I break up? How's it going to be? And you need to set the tone and figure out what you need in terms of your breakup before, because they aren't thinking about that. They want to keep you, and they'll make it hard for you to break up with them. So for my lay folks out there, if you're scared because you don't know all this law, look for the key term. These are some keywords that should trigger that there's a problem. If they're using personally identifiable information of your students, that's going to implicate FERPA. If there's any kind of student surveys, or if this is a website-based service that you're going to use for students under age 13. All of those implicate federal laws that Suzanne's going to tell you more about now.
Okay, and we are short on time, but I will say in the chat, you will see that there is a place where you can leave questions. We won't have time for questions today. Unfortunately, this is such a hefty topic, but if you'd like to put questions in the chat, we will certainly look at them and we'll get back with you, or you've got our email addresses, which are on the materials, which will also show at the end of this, and you're welcome to email us personally if you'd like to. So that's fine. We're happy to respond. If you are a private entity, you can sort of half turn off here a little bit, but I still would keep one ear open because these are good privacy practices no matter what your rule of law is. But if you are a public organization or you are a private organization that accepts federal funding, then you are subject to the Family Educational Rights and Privacy Act. That is whether or not you are a K-12 entity or a post-secondary, a university or a college. So this is going to apply to you. But even if you are a private school, I still would consider this a best practice. Essentially, personally identifiable student information is private, and we can only release it under certain requirements. One of those requirements that's the most helpful in tech agreements is if we designate this technology company as a school official. So basically, they're going to do something for you that you would normally do for yourself that's very broad. Maybe they're going to teach students or maintain student information. A lot of what you're getting these tech agreements for really would meet that first bullet at the bottom of the slide there. But the most important thing here, I would say, are the last two bullets on the page, which is in order for you to designate them as a school official, which allows them to get educational information from you without getting a subpoena or a parent authorization or anything, you can just share it with them the way you would share it with any other school official within the school system, is that they have to be under your direct control with respect to the use and maintenance of education information or PII, and they also can't release any of that information without compliance with FERPA. So basically the law says, look, we'll give you this little loophole, but they have to be doing something that you would have done for yourself, and they've got to be under your control, and they essentially have to comply with FERPA themselves. So this allows you to share this information with a technology company like a student information system vendor without getting authorizations, but you still have to make sure your contract is clear that they are under your control. So that's really, really important. And I would say even if you are a private organization, I would still put those terms in there because it's important. Next slide, please. And if you are looking at, sorry, I think I've got a different slide next than you do. You can only share, this vendor can only share the PII for the purposes of the agreement and pursuant to applicable law. Again, they've got to comply with FERPA. We need to make sure they're using reasonable methods to make sure they're only getting the information that they're required to do. You don't want to do a whole data dump of your student information system when really it's just for 7th graders, or really it's just for freshmen in college. So we want to make sure we're only giving them what we have to. And when you can, share de-identified or anonymized data that cannot be re-identified with vendors. So you've got to think, okay, and not only am I taking their names out, but I'm making sure I take everything out that allows them to go behind me and identify them another way. And of course, the last bullet, most important, I think, of the whole privacy thought is be jealous of your data. Keep ownership over your data. Make it clear in the contract that you continue to own the data. And when we break up, this is like a big prenup, right? When we break up, you're going to give it back to me and you're going to destroy what you have because you don't get to keep that. That's mine. I'm jealous of it. These are my children. These are my students, and I will keep their data. There's another law called the Pupil Personnel Act. And really, this is another privacy act that really only applies if you are a public entity. So if you're not a public entity and you don't interact with public funding, this will definitely not apply to you. But essentially, I'm not going to belabor this part. If you are going to have a product that is going to be spitting out what I call sex, drugs, and rock and roll surveys, then you need to remember that the PPRA is going to control that. And sex, drugs, and rock and roll surveys that are also funded by the DOE has to provide written parent consent and an opportunity for parents to say, I don't want to be involved in that, and an opportunity to inspect it. Even if it's not funded by the DOE, but it's a protected area, sex, drugs, and rock and roll listed there, we still have to provide them notice and an opportunity to opt out. Next slide. And you have to also give parents an opportunity to opt out of instruments that are distributed to students that collect marketing, sales, or information that's going to be distributed for that purposes. So that's just to keep in mind. If anything that's going to be going through this product that you're buying is going to be doing surveys or getting information for marketing or sales, you've got to be thinking about PPRA. You should, next slide, have a policy on it. And again, this isn't going to be the most common thing, but I do think it's one of the most commonly overlooked issues when surveys and marketing materials come up. And it's quite complicated, to be quite honest with you. So if you have a concern about PPRA, this is one of those situations where I would ask for some assistance from an attorney, maybe do a little splurge there. And again, that's going to be public entities that are going to be worried about that. Next slide. COPA. Bottom line, COPA is a federal law that impacts operators. Operators are the people that are running these websites, running these apps, running these technological products. It's really a law that affects them, but they will try to pass the buck to you. So if they are marketing to children under 13, they will try to say, oh, you are a responsible school district or college or university, which you shouldn't have any college or university products that meet this, but you never know if you have some sort of training program or teaching program for children within your university. They will try to push this onto you. And that's what we want to avoid. We want to avoid you taking responsibility for their COPA requirements. However, I will say that part of COPA is requiring these operators of these products to get parent consent. And the FTC, which really controls this process, has said, look, we get it that it's hard for these vendors to go to every parent and get consent. So one thing the school districts can do to help, and this is pretty common that they would take on this task, is to make sure we're notifying families every year and giving them a chance at least to opt out if they don't give consent for us using these products with children under 13. So just remember to be familiar with COPA, know that it is a thing, know that it should not be being passed on to you. Next slide. This is an example of exactly what you don't want. You acknowledge and agree that you are solely responsible for compliance with COPA. No way. Will you take on some limited requirements of getting consent? Sure, but you need to spell that out with the organization, what you're willing to do, and everything else goes back on that vendor.
Real quick, pitfall number 9 is that a lot of folks don't understand that if your technology vendor is located outside of the state of Georgia, but in your public institution and the contract for your technology services exceeds $2,499.99, you are required to get an E-Verify affidavit. If your technology service provider is totally located outside of the U.S., it is not required, but in Georgia, the vendor does not have to be physically located in Georgia for that E-Verify affidavit to apply. All right, we're finally getting to the end here, and this is our final tips reminder.
We have so much to say about this topic, clearly.
I tell you.
Yeah, it's a big topic. So here's our final tips. For my public institutions, start with a strong solicitation. Make sure that it's up to date for data, for data privacy, for digital purchases. Next, require all contracts and incorporated agreements, terms, policies, everything to be provided to you, either with the BAFO or upfront, with the contract that they're trying to get you to sign. No links allowed. Never allow a link, because that means that they'll be able to change it. Use your own template for digital purchases if possible. Have an attorney make that for you. It's worth it, because it also decreases the amount of time that you have to spend negotiating. And just read everything that you get. You may click I accept on your iPhone agreement, but when it comes to things that you're accepting on behalf of your institution, you've got to look at every single thing. And don't be afraid to negotiate. And once you do, make a copy of what you negotiated, put it in the contract and say, this is the one that applies. Nothing, you can't change this. Nothing else applies except what we have agreed to here.
Right. Be sure to attach the specifications that you've agreed upon to your contract. Think about including what kind of practical remedies that you need to cover potential and probable losses, and negotiate those, include them in your contract. Do not waive your significant warranties or in the indemnifications that come with those warranties. Always require strong cyber insurance and ensure adequate coverages under other policies.
And that's it. We have, here's our information. If you're interested in reaching out, or if you want to drop a question in the chat, we're happy to reach out to you. And I hope this was helpful today. Thank you so much for taking your valuable time out of your day, and we really appreciate your attention.